Have you ever wondered why some countries have a single, definitive book of rules for their government, while others seem to manage just fine without one? It is a fascinating question that reveals much about the foundational principles of nation-states. Structurally, written and unwritten constitutions primarily differ in their physical form and codification. A written constitution is typically embodied in a single document or a closely related set of documents, deliberately drafted and formally enacted as the supreme law of the land. In contrast, an unwritten constitution is not contained in one specific text but is instead a collection of statutes, judicial precedents, constitutional conventions, and historical practices that have evolved over time. The fundamental reason for this structural divergence often lies in their historical origins. Written constitutions frequently arise from a specific moment of national creation or transformation, such as a revolution, independence, or unification, where a conscious decision is made to establish a new order. This deliberate act leads to a unified, codified text. Conversely, unwritten constitutions, like that of the United Kingdom, often evolve incrementally over many centuries, accumulating principles through parliamentary acts, common law rulings, and accepted customs without a single founding moment requiring formal codification. This evolutionary process naturally results in a dispersed, rather than a concentrated, structural form. Understanding these structural differences helps us grasp their practical implications. For written constitutions, the codified nature means that identifying core constitutional principles usually involves consulting the specific document. Amending a written constitution often requires a special, usually more difficult, procedure than passing ordinary legislation, reflecting its supreme status and rigidity. With unwritten constitutions, interpreting constitutional law involves analyzing a broader array of sources, and amendments can sometimes be made through ordinary legislative processes, which tends to make them more flexible. These distinctions also introduce terms like constitutional conventions, which are unwritten rules of political practice that are considered binding but not legally enforceable in a court. For example, the convention that the British monarch will grant royal assent to bills passed by Parliament is a crucial, though unwritten, part of their constitution. This reliance on convention highlights the fluidity and adaptive capacity inherent in an unwritten structure, often built on centuries of tradition and precedent. Ultimately, recognizing the structural variations between written and unwritten constitutions provides clarity on how different states establish, maintain, and adapt their fundamental governing principles. It helps illuminate the interplay between deliberate design and historical evolution in shaping the legal and political frameworks that define national governance and protect individual liberties.